I'm disappointed in you. When I tell you I'm not going to adjourn something, you don't submit a stipping order to adjourn behind my back with the hopes I'll forget about it and sign it. I'm serious as a heart attack. He will be sitting in that lockup unless he's married to a physician for the longest time. Why would you do such a thing? I don't care what your client asks you to do. Mr. Knight, you and I are going to talk.
I know, Judge.
I'm not happy.
Not,
Eric Tarenti Bagaya, Jr., 26F2622289. Your appearance?
oh, Judge, Patrick Rhinus, P76.
Oh, this is the one.
Tomorrow.
Yeah, I know. This is the one. I want you up here. Your appearance.
Patrick Rhinus, P76343. Sorry, Judge, I was very confused.
Well, I called it because I got this stipulated order adjourning bench trial.
Correct.
I had told you last time I was not going to adjourn the trial.
I understand.
Why in the world would you do that and submit that with the hopes it's going to get by a judge? Either that or you thought I was kidding.
No, Judge.
I don't kid in here. I have a very good sense of humor outside of here, but I told you I wasn't going to adjourn this. And then I get a stipulated order, like I sign 150 to 200 orders a week probably in judgments. Why would you submit an order, a stipulated order adjourning a bench trial when I just got done telling you I wasn't going to adjourn it? I hope you don't do that in other courts.
Judge.
So listen to what I'm telling you, counsel. I am not happy about this. I don't fool around in here. I'm not kidding. You guys had multiple pretrials. And now all of a sudden there's this urgency to adjourn because your client is going to start a job. If you had a pretrial on February the 5th, 19th, 16th of April, February 5th and 19th and March 19th and April 16th. And now you're telling my clerk your client's not showing up and you want to know when you can walk him in. Listen to me very carefully. If he dares plays games with me, like he better have a lot of money. And don't think if you walk in here on Monday or Tuesday or Friday that I'm going to just say, oh, let's let bygones be bygones. He will be sitting in that lockup unless he's married to a physician for the longest time. But more important, I'm disappointed in you. When I tell you I'm not going to adjourn something, you don't submit a stipping order to adjourn behind my back with the hopes I'll forget about it and sign it. I'm serious as a heart attack. Why would you do such a thing?
Mr. Volia asked me if I could do whatever I could to get it.
You brought it up. I said no. Why would you do such a thing? I don't care what your client asks you to do.
Judge, he finally got it before. He has 2 weeks where he can't.
This is an animal violation case. It's a dog bite.
It's a domestic violence judge, and they're going through a custody issue, so that's why he was trying to get it so the custody issue would not affect his.
You mean to tell me if he starts one day later, he can't get a job at Ford Motor Company?
Judge, the email said that he has to be there for 2 weeks straight. Otherwise, he will be terminated from the job. There's no exceptions, no excuses.
When is he supposed to start?
He started on Monday, Judge. So I think he's gonna miss work tomorrow and have to reapply to Florida.
Listen, I thought it was an animal violation, but it doesn't matter.
Now, did you?
Well, why so many? This is a domestic violence case. That's fine. But why so many pretrials? If you guys needed to push this through, I'd have given you a trial date 6 weeks ago.
Judge, we didn't want to push this through. We wanted to work with the family law to get their custody issue set up at the same time as this was being resolved. And they were supposed to have a custody hearing last week, and it's been a contentious issue. So, and he wants to be able to support his 2 children with the victim. He was a former police officer.
I don't care who he was.
And he lost his job, and now he's been working as a plumber, but he's like, I finally have a job to get in at Ford. I can't leave my kids and move some other place.
I know, but if he told you that.
Judge, I begged him to set it. I said, can you start 2 weeks later?
Listen to me. If he told you that, I vaguely remember you saying something about starting a job. Maybe you brought this up.
I don't believe I did, Judge, because I didn't know. He said he was looking for a job. He was waiting on Ford to get back to it, but I don't know if I brought it up. I did bring up that he had custody. I wasn't trying to sneak anybody, Judge.
No, but you can't do this. I was really surprised. I didn't think you would do something like this. You could have filed an emergency motion then and it been explanatory. It said this, that, and the other. All I've heard is adjourn on this case. I don't want to cost anybody a job. Heather, I'm going to forget that Mr. Nienhouse handled this inappropriately.
Judge, I take full responsibility.
Hang on. I'm going to adjourn this. You called Mr. Cayley's office. They already submitted a stip order. I'm going to adjourn this 2 more weeks. Is that going to do it? May 14th?
Yes, Judge.
You sure?
Yes, Judge.
Because you said he started this last week and he needs to be there for 2 weeks, right?
He told me it was 2 weeks. He can't, I was like,
All right, okay, fair enough. For some reason, I thought this was an animal violation.
no, Judge, this was a,
We're gonna adjourn this to, or is it May the 13th, Heather? No, May the
No, 'cause
14th.
it'll be May 14th, Judge. Do you want to
And
do
I'm
it
here
at
that day,
11
right?
o'clock? Yes, you are. Do
What time are we gonna do this?
you want to do
Yeah.
11? Are we doing it as a trial that day?
Yes.
So you want
What?
to do 11 o'clock?
What?
I was gonna say I have a Dearborn at 8:30 in the morning, so if I could just have it after 9:30 or 10.
I'll make it 11. May 14th at 11. I'm gonna forget this happened, by the way. Next time, file a motion, emergency motion. I'll accommodate you with an emergency motion, but I felt like you were trying to get one by on me, and I don't like that.
No, Judge, as soon as I got information from Mr. Bogia, I reached out to Mr. The APA,
May 14th. That's what we'll do.
and I was like, I told him what's going on. I was like,
All right, good enough, good enough. No sense groveling any further, but I was disappointed in you. That's all I'm gonna tell you. It's forgotten. People against Buddy, or Bradley, Brianna Mae Bradley, 26W841845, A and B. Now, what is the situation with this? Ma'am, come on up here and state your name, please.
I'm Brianna Mae Bradley.
So the prosecutor's just dismissing. Is there a reason for it?
Yes, Judge, we found out later on there were co-defendants after I filed my appearances because I just got 2 separate tickets. The co-defendants taking full responsibility for this, and Miss Bradley was, based on the video evidence, was trying to break up the incident.
Okay, so for purposes of arraignment, she stands mute with
Yes.
formal reading. Dismissed motion of the prosecutor.
No.
So he's saying that he's going to go ahead and just, because the co-defendant, Mr. Bradley, is going to take responsibility, right?
Yes.
Okay, good enough. Case dismissed, nolly prost, motion of the prosecutor. Ma'am, he is dismissing without prejudice. I'm not saying he can't refile, but he's not likely to. So I'm dismissing your case. You're all set. Have a good day. Thank you. People against Christopher Bradley. Christopher Brian Bradley, Jr., 26W841844 A and B. Make sure you call Mr. Cayley so he can call off his witnesses on that case tomorrow. Will you please, Heather?
Okay,
No, man. You can call him too. That's fine. All right, your appearance,
Patrick Van P76343, Judge.
sir, your name?
Christopher Bradley.
All right, so we have a disturb the peace in an A and B. And does he stand mute and waive formal reading?
Yes, and Judge.
And so now he's going to plead guilty to both of these, both the A and B and the disorderly under section 771.1. I gotta call in the prosecutor real quick. Mr. Urick, please. I can't do a 771 for 18 months.
Okay.
It has to be disposed of within 12 months. FIDA you can, 769 you can, 7411 you can, any of these other statutes, but you can't do it on a 771. So he's just gonna have to change it or do something else, but I can't do 18 months probation on it.
I should have thought that myself.
That's all right.
I know sometimes you can waive that.
That's all right. Well, I don't.
Yeah, no, I,
Okay, so, sir, do you understand? So first of all, he stands mute, waives formal
Yes,
reading, right?
yes.
And now he's going to plead guilty to these 2 charges, disturb the peace in A and B, and then there's going to be a plea to, Mr. Urick, your name?
Good morning, Your Honor. William York on behalf of the city of Winnebago.
I can't do 771.1 for more than 12 months.
Is that right, Judge?
Yeah,
I apologize.
there's nothing to apologize about. You want to just redo it to 12 months, or you want to do something else with Mr. Nyans?
We'll do it 12 months if the court please.
All right, good enough. So it's going to be 12 months, and that's still agreeable, obviously, with your client, right? Mr.
yes, Judge.
So if you plead guilty to that, sir, I want you to understand that each of these are punishable by up to 500 fines, 90 days jail costs, or all those. I'll take them under section 771.1. The conviction will enter now. I'll send you for a pre-sentence report. And if you're compliant at the end of the year, the case will be dismissed. Do you understand that?
Yes, Your
And did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that? Okay. Do you have any questions on any of your rights? To the charge, disturb the peace, how do you plead?
Plead guilty.
To the charge, assault and battery, how do you plead?
Plead guilty, Your Honor.
On March 15 of 26 at 1:44 PM, were you at 22900 Allen Road near Weston Woodhaven?
Was I there
Yeah.
yesterday?
And what, is that a business establishment?
Yes, it is, Judge.
What is it? What business is that?
It's outside of Christoph's, Your Honor.
Okay. And what happened that makes you guilty of those two offenses? Disturb the peace and assault and battery.
Mutual combat, Your Honor.
No,
Well,
so let me,
No, I mean,
can I,
no, let me ask the questions. Did you come into contact with Joseph Clinton?
yes, Your Honor.
Did you know Joseph Clinton prior to that? Did you just meet him that day?
That was our first meeting, Your Honor.
Okay. And what happened? Did you strike him in any way?
I did strike him, yes, Your
With what?
Honor. My hand.
This? Okay, where'd you strike him at?
Space, Your Honor.
How many times?
Unknown amount, Your Honor.
Pardon?
Unknown amount, Your Honor.
So you punched him in the face multiple times, is that fair?
Yes, Your Honor.
And were you disturbing the peace in some other way? Were you yelling, screaming, swearing?
Other people got out of their cars and it caused the disturbance, yes, Your Honor.
Okay, so what happened? Why did you punch him?
He almost T-boned me and my children, Your Honor.
All right, so he was backing out of a car, out of a parking lot,
No, it
or?
was at the intersection, Your Honor.
Okay, so you got angry with the way he was driving. Is that fair?
Yes, Your Honor.
And then you accosted him or came up to him and started yelling at him. Is that fair?
Yes, Your Honor.
And then what happened? Did he ever punch you or swing at you or take a strike at you before you punched him?
No, Your Honor.
Not before.
No, Your Honor.
So you were the aggressor first. Is that fair to say?
Yes, Your
And
Honor.
that you weren't acting in self-defense?
No, Your Honor.
Are you on probation or parole right now?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
You're satisfied, right?
yes, Judge, thank you very much, I appreciate that.
I'll accept the plea. I'll take it under 771, both of them. And I'll make them 12 months. And we'll set it under, I'll take it under 771.1 commencing on the date of the sentence. I am going to order, he wasn't under the influence of anything,
No.
was he? You agree this wasn't the right way to handle this, right?
Big mistake.
Okay, fair enough.
Told you, I'm gonna take responsibility.
I got it. Mr. Nienhuis, I'm gonna give him pre-sentence report. If you want, maybe I can even do it the same day as your other case. We set it for May 14th, right, Heather?
Yes, at 11 a.m.
Yes, Judge.
Well, let's set this one for 10:45. How's that?
Perfect, Judge.
And then I'll sentence him then. And getting back to the other Mr. Nienhuis, maybe it was just a misunderstanding. I'm gonna give you the benefit of the doubt. And I was just upset when I got a stipend order to adjourn when I'd said I hadn't. And next time I just encourage you to file a motion and explain it, and I'll be reasonable with you, okay?
Okay, please, Judge, I appreciate you.
All right, so you're gonna go down, no problem. You're gonna go down the hall. And just to not carry on here, I've always liked you and so you're gonna go down the hall, get your notice, and then you're going over to probation where you'll be interviewed, okay?
Judge, I do have a question. Can we do
Sure.
it that day, or are we gonna notify the victim on this, or no?
You have to notify the victim.
So does it have to
probation-
be on a Woodhaven day or no? If we have to notify the victim?
Yeah, it should be. That's Woodhaven though, right?
Not on that other day as his other case, because that's a Thursday.
Because that's a flat rock case, Judge.
Oh, jeez.
Judge,
Yeah,
I'll make
so
a
we would-
Okay, yeah.
We
we're
have
gonna
to do it on
make
the 13th.
My mistake.
Perfect, Judge, 13.
Yeah,
And Judge, are both of these being taken under 7711?
both of them will. Yes.
Okay, thank you.
So we'll make it May the 13th then. Are you good at 8:30 or?
Can we get a little later, just to drop my daughter?
I don't have a problem. I'll make it 10:30. How's that?
That works, Judge, thank you.
Okay?
Be here a little early.
I gotta set bond conditions though. I neglected to do that. Your client doesn't have any warrants out, does he?
No, Judge.
He was never fingerprinted on this though, was he?
No, he was not, Judge.
So, sir, listen, I have to order you to go over there and get prints, okay? So here are your bond conditions. I'm gonna give you $1,000 personal bond, okay? $1,000 personal bond on these. And we'll give you a copy of the bond sheet. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed, okay? And I'm going to go ahead and order that you go over to the Woodhaven Police Department to be fingerprinted and photographed by 1 p.m. today, that you not purchase, possess, or purchase or possess firearms or other dangerous weapons, that you not enter the property address at 22900 Allen Road. That's the Christophs. And also that you not have any contact with the victim, Joseph Clinton, okay? So you cannot have any contact with him. You cannot have anybody write him, phone him, see him, text him, email him. You cannot do any of those things for you or on your behalf. You have anybody else do any of those things for you or on your behalf. Do you understand that?
Yes, Your Honor.
And I'm gonna fill out an order for prints, which they're gonna send over there, so you have to go over to Woodhaven today, and we will go from there. Anything else, council?
Bring up the date of appearance, and you'll split for probation, and then we should be done by once, we can get to it.
Absolutely. Thanks a lot. Have a good day.
You just
Thank you.